Forbes magazine once said that data science was the most sexy job in the world, right? Come on now. Okay, sounds fabulous, right? But over the past few years, a few of us have wondered whether data analytics was also the most dangerous job in the world. And if we really believe this, if we believe that data is the crown jewels of our organization, we realize we have the job of protecting them. And if we don't do that job properly, there are a lot of crooks out there who will steal our data. There are regulators and legislators who are out there to set laws and regulations and penalties for not using it correctly. In a very litigious world, there are those who sue our companies for enormous amounts of money in there. So much for the sex appeal of data analytics. But, you would be fair to say, if you feel sort of boxed in by this, that every which way you turn, privacy and security are seen to be an obstacle. But that's not really true. Our former privacy commissioner once chewed us out on that and said, this is not an excuse. It's not an obstacle. It's what is a barrier is the lack of understanding we choose to have on the regulations and the rules that govern us. And now we don't have to be compliance experts. If you're out there saying, well, I'm not in compliance, I'm not in governance, and you don't have to be a compliance expert, but we do, all of us, need to understand the rules under which we have to operate. Like doctors wearing masks in operating rooms, or construction workers wearing hard hats. We observe safety procedures. Or if you get in your car, what do? You put on the seatbelt. We need to know what behavior is expected of us. And not so we have all the answers, but it's impossible to have privacy and protection and governance and security without our cooperation. So some of us might not have to have all the answers, but we do have to know what questions to ask. Now, Jennifer Davidson is a partner with Deeth Williams Wall. Welcome, Jennifer. And she's going to talk to us about some of the latest developments in security, privacy, and compliance as they affect us as data analytics professionals in there. And for business users, managers, and executives. Jennifer, the stage is yours.
My name is Jennifer Davidson. I'm a technology lawyer at Deeth Williams Wall. And day in and day out, I deal with the privacy and cybersecurity issues of companies that are unfortunately going through the hard times. Dealing with security and privacy essentials for data professionals, which is a bit of a mouthful, can take a lot longer than the time that we have today. But I'm going to try to leave it to the things that you need to know and the things that you need to think about. I think I'm pressing the wrong thing. There we go. Okay, so today we're going to go through a couple of things. The growing threat of data breaches, which is really about what you've got to be thinking about every single day. We're going to talk a little bit about cybersecurity attacks and the role of the lawyer in those attacks, and the need to report, which is the question that I keep getting asked. And then I'm going to leave you with a few key takeaways. So the threat of data breaches. We've got an analytics conference, so I'm going to start with a couple of key figures for you. So we're looking at between 5 and 25 million data records that are exposed worldwide each quarter. Between March 2021 and March 2022, organizations are reporting that they have, 83% of organizations are reporting that they have already experienced more than one data breach. And the average cost of data breaches have reached an all-time high of 4.35 million US. And 52% of global organizations surveyed said that they have a supply chain partner that was hit by ransomware. This is where I want to get into, supply chain, because it means that you don't just have to worry about you have to worry about everybody down the line. It's just too easy to go after the supply chain, and really, you get the most bang for your buck. I mean, you want to talk case in point, we can look at SolarWinds. SolarWinds happened in March 2020. Criminals entered into the SolarWinds backend system and inserted malware into the code. And SolarWinds, unfortunately, sent that code right on down the line to about 18,000 of their clients. which, through no fault of their own, of course, they were going through the process of sending through updates. Including in those 18,000 SolarWind customers were 6 U.S. government departments. I bring this up because 2 days ago they made headlines again when SolarWinds agreed to pay $26 million to its shareholders over this data breach and over the failure to actually prevent the data breach. The data breach, by the way, lasted for 9 months. 9 months before anybody figured out that all of these companies were being spied upon, including government agencies. I also want to bring Kronos up here. Back in December 2021, Kronos, which handled payroll software for thousands of companies across the world, including several of the Fortune 500, the ransomware attack ended up taking over their systems, took them down for several weeks, and all of these companies, including some of my clients, were left with payroll systems that they couldn't access, which means you've got 200, 300 employees, all who are expecting payment according to their time cards. Those time cards are gone. Thousands of dollars missing, and missing right around Christmas time, which sort of added to the nature of the response. Kronos wasn't back up again until late January. I mean, it speaks to exactly how much we have to deal with here and how difficult it is. I'm going to skip past Colonial Pipeline and go straight for this one. So as soon as a lawyer pulls up case law, everybody's eyes glaze over. It's, I'm like the tax man. It's terrible. But I want you to pay attention to this one because this was a precedent-setting case that came out back in September. And in this case, we deal with the Insurance Corporation of British Columbia, which held the records of a compulsory insurance policy plan for all of its members. And the Insurance Corporation had obviously all the personal information of all of their insured, and one of their agents snuck online, grabbed the customer data, and sold it. Sold it to a third party. Well, police started investigating after there were a series of arsons and thefts and shootings and found that this list was behind it all. The criminal syndicate was going through the list and actively targeting some of the affected individuals. The reason I bring this case up is because the Supreme Court in British Columbia found that the company was vicariously liable for that damage. The company. And why was the company vicariously liable? Because they didn't insert proper access controls. They had made it so that anybody within the organization had the ability to access those lists. And the court found that damage was foreseeable if everybody had access to that list. Now, one thing I want to point out is that there was training. There were privacy policies. There were a whole bunch of things that were in place, but access controls were not. And so what we're hearing from the courts is loud and clear. We need to actively protect the data, or we're going to be paying the consequences. So cyber attacks, I'm sure you've heard this before. It's not if, it's when. And I hope you never see something like this, but my clients end up seeing it all the time. Your files are locked away from you and you get something like this, and the question is, what do you do? What do you have to do? And so we get called in. And why are we called in? We get called in to be breach counsel because we deal with these things all the time, because we understand how to coordinate an investigation with proper preservation of evidence, and we try to keep it all bundled under privilege because these are things that can come out in litigation later, and there are things that you don't want to come out in litigation later. These are highly sensitive documents that are coming through, and the unfortunate thing that we end up having to deal with is if we're not called in soon enough, we can't put the cat back in the bag. The information has to be created for the purpose of getting the advice of counsel, and counsel has to be on board and be part of those communications in order to try to protect it under privilege. Unfortunately, we saw something like this with Life Labs, when Life Labs had a large breach. They didn't bring in counsel. They hired a forensic team, and the Privacy Commissioner asked for that information, and that information was not protected under privilege because there wasn't a lawyer working on the file at that time. So the next question I get, I've been hit, do I need to report? It's not a simple answer. Under federal law, you need to report if there's a real risk of significant harm to the affected individuals. How do we know what is a real risk of significant harm? Well, the test is not an easy one, and really a lot of it depends on the facts of the case. But you have to look at this from an objective viewpoint and say what could happen to these individuals based on that circumstance. And so what happens when you need to report? Who do you need to report to? Well, Privacy Commissioner, individuals, and other organizations. Now, most companies are aware that they may have to report to the Privacy Commissioner. Most companies are aware that they may have to report to the individuals. But the other organizations, that sort of sits there floating. And what does that mean? That means there may be regulatory bodies involved that you may need to report to. It may mean that you need to contact police, where there's a threat of where the threat of the threat actor is really ongoing, and reporting this would actually mitigate that harm. And what happens if I don't report is the next question. So the fines currently are an offense punishable by summary conviction, liable to a fine not exceeding $10,000, or an indictable offense. And the indictable offense can have a fine of $100,000. And that's under our current law. But things are changing, and they're changing dramatically. Back in June, there was a bill passed, a couple of bills passed, one of which was C-26. C-26, the Critical Cyber Systems Protection Act, is creating a mandatory reporting for all cybersecurity incidents for any company that is part of critical infrastructure. And you might think, okay, well, I'm not part of critical infrastructure. I don't work for the energy company. But when you look at the wording of this act, it's time to pay attention, because the supply chain comes back into effect. Everybody who's down the road from the supply chain, if they're affected, and that means a critical infrastructure is affected, then that reporting strategy, that reporting mandate comes into effect. And another reason you need to pay attention to this, contraventions of the Act can incur administrative monetary penalties of up to $15 million per violation. That's worth paying attention to. Another bill that came into place at the same time in June, and keep in mind these are bills, these are not yet acts, but another bill that came into place is Bill C-27, the Digital Charter Implementation Act, and this affects every analytics professional, because you are now dealing with a new series of questions about what you are allowed to do with the data that you have. There's new rules about the collection, use, and disclosure of the data, the manner that it was collected in, the consent that you receive at the time of collection, and that organizations that are operating with AI systems, that have high-impact AI systems, have to adopt measures to identify, access, and mitigate the risks of those harms or bias outputs. This is new, and this is going to change a lot. We've got a whole lot of AI transparency coming down the line with this stuff. And then they've gone a GDPR route, and they've said that contraventions can lead to up to $10 million, or 3% of the organization's gross revenues, or if they knowingly commit certain offenses, then they can face fines of greater than $25 million and 5% of the organization's gross global revenue. Again, worth paying attention to. Now, I've talked to you about federal legislation, and I've seen the eyes glaze over. But federal legislation doesn't actually cover us for what we need to know here, because there are provincial legislations as well. They don't cover everywhere. They cover Quebec, Alberta, and BC right now. But it's not enough to know what the federal rules are. If you're operating in any of these provinces, or you have individuals from these provinces that could be affected, then you need to pay attention to this legislation, because you're going to need to report in these locations as well as the federal. So we can go through each and every province, but you've got to know that they're pretty much substantially similar to the federal legislation. You just have to remember that it's only applicable to that province. But then there's Quebec. So in September 2022, Quebec decided to really bolster their privacy. And in doing so, they've created a regime that comes into place over the course of 3 years, September 2022, September 2023, September 2024. And in each of these years, they've got increasing mandates of what you need to do. So in the first iteration of this, when we're looking at September 2022, we now know that every organization that operates in Quebec or with Quebec needs to have a privacy officer. If you have not designated a privacy officer, then the CEO is automatically allocated the responsibility. It's not enough to just list them as the privacy officer. You also have to inform on contact information within your website on how to reach the privacy officer. Quebec has mandatory data breach reporting requirements, similar to the real risk of significant harm test, but this is a real risk of significant injury test. There are record-keeping obligations, which means that you've been hit, there's personal information, there's no personal information within the attack, you still have to record and keep a record of all the things that you did in response to that attack. And then there's a registration for biometric systems. Moving towards 2023, there's going to be a mandate to implement policies. Privacy policies need to be up on the website. The collection of personal information requires a legitimate and meaningful purpose, which will need to be identified beforehand. So there are increased disclosure requirements and increased methods of sharing those requirements that you're going to have to know before you're using your data in analytics. And all privacy settings, where there are privacy setting options, are going to have to be defaulted to the highest level of confidentiality. Now, you were talking earlier, Joe, about the privacy commissioner who told you that it didn't have to be difficult. I'm going to guess that she was talking about privacy by design. Yes. Privacy by design has made its way into our legislative system, and we are going to have to make sure that we are taking it up a notch. Also, before you can take data out of Quebec, you're going to need a privacy assessment. So some key takeaways. There's a lot of new privacy laws coming into play. Understand them and understand what your company needs to do in order to be able to comply, and don't leave it to the last minute. A lot of these things take a lot of time. It takes a lot of structure, and you're going to need to organize. So pay attention to it now. Make sure that you're not just cleaning up your own backyard, but you're also making sure that your supply chain partners are also protecting themselves. That means going back through your contracts, making sure that those contracts have data breach reporting and safety provisions. You need to develop policies and procedures to safeguard your privacy and the privacy of the individuals that you're working with. And please stay tuned for more developments in privacy law. Thanks very much for your time.
Thank you. It was fabulous. Thank you so much. I have a question, and this is a question that always bothers me. How do we know which legislation is applicable to us in a country like this?
It's a really funny thing because it really depends on what you're dealing with. So when you're dealing with privacy, the federal privacy legislation presides over the entire country,
Yep.
except where there's a provincial legislation.
And so the provincial legislation can override that. But
That's
even if
right,
I'm operating in
within that
Ontario,
jurisdiction.
I think what I got from you is, even if I'm operating in Ontario, if I have an impact on somebody in Quebec, I still have to watch it.
Report in Quebec.
You have to report in Quebec.
And you've got to comply with Quebec law when you're dealing with Quebec residents.
Wow.
So it's not enough to just know, I'm in Ontario, my business is in Ontario, so I only need to understand what's going on in Ontario. No, you need to understand what's going on in Ontario, what's going on in Quebec, and if you're dealing with people from Alberta, if you're dealing with people from British Columbia, you need to know what's going on there too, because everybody has slightly different wording as to what they're looking for and what needs to happen, particularly when there's a data breach.
Ah! I don't need an alarm clock anymore. Between this and security, I don't need an alarm clock. I wake up in the middle of the night screaming. But thankfully, we've got people like you to help make sense of this for us in there. And again, I think this is an important thing that we shouldn't be frightened by. I make a joke out of it. We shouldn't be frightened of it. We should be aware of our responsibilities, because we always say in security, as well as you need everybody in the organization. It takes only a mistake by one person to trigger something that can have great effects on the organization. So we all have to know what we're handling is valuable and that there are rules in place about it.
Exactly.
Thanks for spelling it out for us. You've been wonderful. Thanks.
Thank you.